Try now. Okay, there we go. All right. They haven't arrived? Okay. We'll start with them. All right, Mr. Lemon, what's your issue? Can't hear a word you're saying. What?
Your objection to force overruling our objection.
Can't hear you. Do you have your mic on?
Yes, Judge, we'd just like to renew our objection to overruling any future activity involving the state having a juror point at the defendant that say this man deserves to die. He did.
All right, the court reporter couldn't hear you. Go ahead.
Judge, during one of the jurors, the state asked if the juror could ask several of them, Loyd, pointed at the defendant, the state pointed at the defendant, and said if they could say to this man he deserves to die for what he did.
Response from state.
They never asked the juror if they could say to that man, they said they could walk into this courtroom and say that this man deserves to die for what he did, which is basically the question in this case.
Actually, you did. On the last juror, it was, I caught you one time doing it. You turned around and say, can you look and say, this man deserves to die? So don't.
I'm pointing, not the juror, though. I was pointing at him. I didn't ask the juror to come in and point to him and say that.
Correct. That's what they're objecting to, is you pointing to Mr. Loyd.
Yes, ma'am.
So what's your response to that, is what I'm asking you.
I mean, I don't think it's improper. I don't see any, I don't know the basis of the objection. It's a legitimate question asked to get to the juror's ability to make that ultimate decision, and that's in essence, by voting for the death penalty, that's in essence what the juror is being asked to do.
That's first of all, that's a misstatement, Judge. They've asked jurors multiple times during their jury selection, can you vote for death if you find da, 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 da? Can you vote for death? Can you vote for death? So that is only intended to prejudice my client, and I would object to it.
Okay, your objection's noted for the record. Do you have any case law that says that that's not allowed?
I haven't looked up any case law, Judge.
Okay. Bree, what room are you in? You're in room 1. Are you on Markeith Loyd trial? E-R-E-E, right? No, I'm not seeing it. Oh, here it is, Marquez PM. Yeah, it's Marquez PM. All right, thanks. Okay. We got 4 jurors left from 10:30.
So you're going to overrule my objection and continue to allow him to do that?
I'm sorry?
You're going to continue?
I overruled your objection, yes.
And you're
All
going to
right,
continue to allow
let's
him
bring
to do
the,
that?
that's what overruling an objection means. We're done with this discussion. All right, let's bring in the next juror, which is juror number 59, 734. What panel is this? I'm sorry, just give me a minute. I have to keep all this paperwork straight. Oh, this is the wrong panel. All right. All right, this is juror number 59 or juror number 43 in seat 59, correct?
Yeah,
All right, thank you, ma'am. How was your lunch? Good?
it was all right.
All right. Did anybody talk to you or say anything to you about this case while you were at lunch?
No, I sat in my car.
All right. Did you hear anything about the case at lunch?
No.
All right, let me take this off so you can hear me. All right, ma'am, we're going to be asking you a few questions. First, I'm going to ask, and then the attorneys get their chance to ask you questions. So, let me tell you, there aren't any right or wrong answers. We're just looking for you to tell us what you actually think and feel. You understand that? Okay. So, have you heard anything about this case?
when it first started.
Okay, where did you hear it and how much did you hear?
Pretty much on the news and my parents and friends talking about it.
Okay, did you guys have a lot of conversations about it or just a few?
Just a few.
How much of the news coverage did you watch?
Not much. It's more hearsay.
Right. And as a result of that, did you form any kind of an opinion as to whether or not Mr. Loyd is guilty?
No.
Okay. Did you form any opinion about anything about the case or about him?
Not really. When I heard it, I said he was wrong for it, but other than that, I just dropped it.
Okay. Jurors are required to be able to sit here at the start of this case and presume that Mr. Loyd is innocent until and if the state can prove that he's guilty beyond a reasonable doubt. Can you do that in this case?
Yes.
Do you have any religious or moral objections to the death penalty?
Somewhat.
All right, what do you mean by that, ma'am?
I too much don't believe in the death penalty myself, not religious-wise.
All right, so you have a personal, a
Yes.
personal objection to the death penalty. How strong is that position of yours?
Pretty strong, I guess. My parents always raised me to whatever I believe in, or I stand by it.
Okay. In this case, you have to be able to listen to the evidence. If you got to a penalty phase, all right, you'd have to be able to listen to the aggravators, the reasons the state believes that death is the appropriate sentence, and the mitigators, the reasons the defense believes life without parole is the appropriate sentence. But you have to be able to go back in the jury room and weigh those fairly and openly. You have to be open to this. So if you went through all of that, and you went through all the evidence, you talked to your fellow jurors as much or as little as you wanted to, and you felt that the evidence and the facts led you to believe that death was the appropriate sentence, could you vote for death?
Yeah, possibly.
Okay, yeah, possibly. What does
Yeah.
that mean?
Yes, ma'am.
Ma'am, I'm not trying to get you to agree with one thing or another, okay? It's very
It
important.
depends on the facts of the case, of how what I see, or because I really didn't really follow the case. I don't really follow the news too much.
Well, you're not supposed to know what you think are facts about the case
Yeah.
because facts about the case come from the witness stand and from physical evidence that's introduced. It doesn't come from news reports and what the neighbors said or anything else. And that's why we limit jurors to what they hear in the courtroom. But as I told you before, this is sort of a separate issue, which is that sometimes people's feelings about the death penalty are so strong that they can't put them aside and they really can't follow the law on the death penalty. And that's fine. If you can't, this isn't the case for you. If you can, that's fine too. So take a minute and think about it and think about whether or not, if you got to that point, you could actually vote for death if you thought that was the appropriate sentence.
I don't think so.
Okay. State.
State moves.
Defense. You may.
How are you doing, ma'am?
Good, and yourself?
Good, thank you. You said that this belief against the death penalty is based on a religious view?
More on my own view, not my religious view.
I'm sorry, I didn't hear the last part. More on your own?
Yes, not
Okay.
religious.
And what is that belief exactly?
I believe, like, people that actually know what they've done and they don't need the death penalty. I think they need to sit there and think about what they've done. The people that are crazy and already they're gone in their head, then those are the type of people that need the death penalty.
Okay, what happens if there's a situation you believe someone murdered someone and the sentence was life or death? Would you be able to look at the death penalty and consider that, or you would never be able to consider that?
I think I'll more fall on life in prison.
Okay, But, so you would never be able to consider the death penalty as a possible sentence?
I don't think so. I don't think I can look at that myself.
Thank you, ma'am. No objection.
All right, thank you, ma'am. In that case, this really isn't the case for you. We appreciate your time and your willingness to serve. You are discharged as a juror in this case, and you are free to go, ma'am.
Thank you.
Thank you. All right, that is for now all of the jurors from the second panel. We're moving on to the third panel. All right, juror in seat number 3, please. Welcome back, ma'am. How was your lunch? All right. Did anybody say anything to you, or did you hear anything or read anything about the case while you were at lunch? All right. Ma'am, you indicated to me that you've heard something about this case. Is that correct? Okay. All right. Was that when it first happened? How much of that did you watch? Okay. Did you hear anything about it, like other people talking about it, family, friends, coworkers, anything like that? So it was just what you saw on the news? Anything in Facebook or Instagram or, the internet, anything like that? Okay. So based on what you heard, did you form any opinions about whether or not Mr. Loyd is guilty? No? Can you put all of that out of your mind and focus just on what you hear in the courtroom? Jurors have to start all trials with the presumption of innocence, presuming that Mr. Loyd is innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe you can do that in this case? Do you have any religious or moral objections to the death penalty? What is your position on the death penalty? Okay. Is that mic on? Because I'm really having trouble hearing her. Sorry. Thanks. Okay, let's try this again. So you said when it's warranted?
Warranted.
Okay. Are there any cases in your mind that you would automatically think, man, yeah, that's a death penalty case?
Not until I've really heard everything. I don't think I could make a judgment ahead of time.
Okay.
Because it's such a drastic thing to not to know what's going on before I make a decision like that.
All right. So if at the end of the penalty phase, the state's presented their evidence of their aggravators, the reasons they believe that death is the appropriate sentence, the defense has presented their evidence of their mitigation, the reasons they believe life without parole is the appropriate sentence, you're going to go back in the jury room with instructions from me. You and your fellow jurors can talk about it or not talk about it. It's really up to you all. We don't direct what happens in a jury room. But you've got the instructions on the law, you've heard the evidence, the facts. If at the end of all of that and you're thinking it through, you have to make the decision for yourself, and you believe that the evidence and the facts support a vote for life without the possibility of parole, would you be able to do that?
Yes.
And if it supported a death sentence, would you be able to vote for that?
Yes.
All right, you heard me explain that Mr. Loyd has raised the defense of insanity, not
Yes.
guilty by reason of insanity. All right, that would occur in the guilt phase when you're all trying to decide whether he's guilty or not. The burden's on the defense by clear and convincing evidence, but let's say at the end of all of the evidence in the guilt phase, you felt that they had proven he was not guilty by reason of insanity. Would you be able to enter a verdict of not guilty in this case?
Yes.
And lastly, you heard my instructions as to the conviction for the murder of Sade Dixon and the unborn child and the life sentence, that you can't use that to determine whether or not he's guilty of this case. Do you understand that?
Yes, I understand.
Do you think you'd have any trouble putting that out of your mind and not using it for that purpose?
I don't think so.
All right. Thank you so much, ma'am. I appreciate your time. State, you may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
So the questionnaire that you filled out for us indicates that you were a juror in the past. Is that right?
Yes,
Did you actually have an opportunity to listen to evidence and render a verdict, or
yes.
you did? Okay. And how long ago was that?
I don't remember when, but I want to say it was in the early 90s.
Okay, so it's been some time.
Yes,
Here in Orange County or somewhere else?
here in Orange County.
Do you remember the charge in the case, or was it criminal or civil?
Criminal,
And do you remember the charge or the nature of the crime?
murder.
See, this is why we ask these questions, right?
Yes,
So you were a juror on a murder case here in Orange County, mid-90s, early 90s?
I think it was the early 90s. I can't remember exactly.
Okay. Were you the foreperson of that juror?
No, I was not.
Jury? You were not the foreperson. Don't tell me what the verdict was, but did you all reach a verdict?
Yes, we did.
Okay. Can you describe that experience for me? In other words, whether you found it rewarding, you didn't like it, it was bad, good, given the similarities in the two circumstances.
It wasn't a very long case, but it was interesting. I felt good about serving on a jury and being a part of that process.
So nothing bad happened that made you dislike the experience?
Nothing bad happened, no.
Was that a case where the state was seeking the death penalty?
No.
Your answer regarding your opinion on the death penalty leads me to believe that you have considered the concept of the death penalty prior to today. Am I accurate on that?
Yes.
All right. There's a lot of space within your answer. When it's warranted can mean a lot of different things. Let me ask it this way. Do you think it's overused or underused or just about right?
It's hard for me to say because I haven't been in that position.
Right.
But I think you have to hear what the case is about and be able to weigh the evidence at that point.
Okay.
I can't say one way or the other at this point.
That's very fair. Do you follow the news or criminal cases at all?
Very rarely.
Very rarely. Can you
I don't
think-
watch the news.
You do not watch the news.
No.
Ask why?
I'd rather read.
Okay. Can you think of a case that you heard about the factual scenario of either on the news or even a fictional case in a book that you've read where, based upon the way the murder was committed, you thought that in your mind the death penalty might be appropriate?
Sure.
Can you tell me about one of those circumstances?
Just what I've seen, like on TV shows, and it's just, I mean, it's fictional, of course, because it's TV.
Right.
But when you see this mountain of evidence presented in court, you think, oh, he definitely must be guilty, and
Okay.
they sentenced them to death, and that's what was warranted, apparently, by that jury on TV. So I don't know.
And there are circumstances where you thought that you agreed with that?
Yeah, just because it's, when you get wrapped up in a TV show, you kind of feel for the people.
Are there any particular circumstances where you think death would, a sentence of death would be not an automatic for you, but that you would lean hard in that direction? And I'll give you an example that's not associated with this case. The death of a child, right? Some people say or believe that if another individual murders a young child, that for them that's just sort of beyond the pale. Is there anything like that for you that you can think of?
I think it's terrible, but I don't know that I could not render a good verdict with that, whether or not after I've heard what the case is about. I would feel really sad about a child being killed for sure, and it would break my heart, but I don't know that I would not be able to be impartial. I don't know about that.
Yes, ma'am. You've obviously been told already that there's an allegation that the victim in this case is a law enforcement officer.
Yes, sir.
Anything about the nature of the victim and the fact that she was a law enforcement officer that you think would prevent you from being fair and impartial in either phase of this trial?
I don't think I could be, I think I could be very impartial. I don't find that I'd be judgmental at all.
Okay, so that fact alone doesn't do anything.
No.
Okay. You said, well, the judge gave you, I think it was before lunch, sort of an overview of the process. Do you feel comfortable that you know what your role is in this process if you're selected as a juror?
Yes.
Not, obviously you've been a juror on a murder case for the guilt phase, but I mean for the second phase where a sentence would be recommended. Do you feel comfortable about what your responsibilities would be?
Yes, I really do, yes.
Okay. And you've said several times that you want to hear the evidence before making a decision.
Absolutely.
Can you think of any set of circumstances where what you heard would be so upsetting or make you so angry that you couldn't wait and withhold a decision on whether or not death was appropriate until you'd heard all of the information that's going to be presented to you?
I would want to wait till I hear everything.
No matter what?
Yes.
Okay. On the issue of insanity, the judge just basically told you that that is a possible defense in this case. And I heard you say that if you believed it was proven that you could find a person not guilty by reason of insanity.
Yes.
Did I hear that correctly?
Yes, yes.
Right. Because of that being an issue, I need to ask you if either you personally or anybody related to you, I'll say close to you, doesn't have to be related, has ever dealt with mental illness significant enough that you think we should know about it?
I had 2 late husbands, ex-husbands. One committed suicide and one attempted suicide and was also diagnosed with bipolar.
Okay. And was it the more recent late husband that was diagnosed or the first one?
The first one.
The first one. Right. Did you ever go into any doctor's appointments with him or anything?
No, I did not.
Did he seek treatment for that mental illness prior to his death? And I'm sorry for your loss, by the way.
He sought treatment when...
Okay. Is it your belief or understanding that that arrest was as a result of his mental illness? You think so? Okay. Did you have opportunities during your relationship with him to see him while he was, for lack of a better phrase, under the influence of that mental illness?
I'm sorry, say that again?
Sure. Did you ever interact with that individual when he was under the influence of that mental illness, when it was active?
Yes.
All right. Was it something that you knew quickly that it was acting upon him, or was it hard to detect?
It was hard to detect to me.
Okay. Tell me about that. How would you know that disease was acting upon him as opposed to when he was more stable?
I only knew, it was hard for me to understand because it was like a roller coaster.
Mm-hmm.
You know, things would be really happy at one moment, and then he'd be in a depressed setting the next. But I didn't really realize that. I thought it was just like he was having a bad day or something. I didn't really realize it was a mental illness or anything like that. And when he was down, depressed, that's when he would go out and get drugs and stuff and do bad things.
So that illness developed into a substance abuse issue.
Yes, it did.
And I'm guessing that substance abuse developed into law breaking.
Until in law enforcement, yes,
Yes,
correct.
ma'am. Okay. I'm sorry you had to go through that. How was it that you ended up finding out that his behavior was a result of mental illness?
He attempted suicide, and he was put in a Baker Act hospital thing.
Involuntarily hospitalized?
Yeah, something.
Yes, ma'am.
And then he was put on medication, and then he went off of his medication and decided to do whatever he wanted to do.
when he was on his medication, was he able to remain stable?
I didn't see it.
You didn't see it. Okay. Thank you for answering those questions.
Yes.
Given that anything about that personal experience or experiences that you think would make it difficult for you to fairly and impartially weigh a defense of not guilty by reason of insanity?
I still think I can be very fair.
Okay. You would essentially be asked to put those circumstances out of your mind and make a decision based only on the facts and law that you heard. You think you could do that?
Yes, absolutely.
Okay. So the situation with your ex-husbands is kind of what I'm referring to with this last question. Is there anything else in your background or life experiences that you think we should know about you, given that we're trying to select a fair and impartial jury to decide this very important case?
No.
Like normally I would say like you were a jury on a murder case, but we've already
Yes.
gone through that. So-
Right.
Okay. All right. Thank you very much, ma'am.
You're
Thank you,
welcome.
Anna.
Thank you, Mr. Williams. Mr. Lenneman, you may inquire.
Thank you. Good afternoon, ma'am. How are you?
I'm good, thank you.
So the last thing one of the last things I heard you say is that you are a person who believes that you can be very fair.
Yes, sir.
Okay. And so in relation to the death penalty, can you tell me why you think you can be very fair?
I believe that I can look at all the evidence and hear everything that is said and make a fair decision whether it should be death or for life without parole.
Okay, and that's a general statement. That's not really speaking to you as a human being. Why, as you as a human being, do you think you can be fair in death penalty?
It's just my personal feelings, I guess.
Okay. Do you consider yourself to be compassionate?
Yes,
Is that something that has followed you most of your life?
absolutely.
You've already mentioned that you can keep an open mind and listen to all the evidence.
Yes,
And I know you had mentioned earlier that you understood what your responsibilities were in regards to the death penalty,
yes, I do.
and that was just based on what the judge told you generally, right?
Correct.
You don't know what the rules are?
No, I don't.
Okay. We'll talk about that in a little bit.
Okay.
If you were placing yourself on a line where one stood for the proposition that you would never vote for the death penalty, and 10 stood for the proposition that you would always vote for the death penalty, where would you put yourself?
6 or 7.
Okay, and tell me why.
Because when something is that drastically a crime that's that drastically committed, then it warrants that penalty as a possibility.
Okay. Now, the judge said not every case is a death penalty case. Do you believe that just because we're here on a death penalty case, that Mr. Loyd deserves to die if he's convicted of this crime?
Not until I find out what the evidence is, no.
Okay. And do you think that there are cases you had talked about that, in your mind, warranted the death penalty? I think we talked about watching TV
On
on
TV.
shows and things like that,
Right.
where you agreed with them.
Yes,
So let me understand the circumstance of that situation. You're watching a TV program. They go through the evidence that someone narrates,
yes,
show pictures and plots and so forth and so on, like the
Right.
forensic files.
yes,
Okay. And then at the end of that, they say, you know, he was found guilty and he received a death penalty. And you're saying to yourself, yeah, I agree with that.
after what I saw of the evidence that they showed me on the show, yes.
Okay. Now, there were no rules guiding you on that.
No.
So what caused you to believe that a death penalty was warranted?
Just from what I had seen as far as the evidence that was shown in the TV show, plus my general feelings as you get kind of attached to a character or whatever, then you kind of feel like that's what you would judge as a fair verdict. But
Okay,
it's like, it's TV.
right. But when you say character, what are you referring to?
Well, I'm not talking, the shows that I watch are more like Law and Order or NCIS or things like that.
Okay.
I have seen the Forensic Files, but I don't watch them very often. And it's more of like a story, you know, you get attached to certain characters, you know, on the TV shows, and you think, oh, well, if they presented it that person was guilty, then you kind of feel like, oh, well, I like that person, so she must be right.
Okay, so in those shows, they're presenting that that person is guilty of killing somebody. And your ultimate decision, or your belief, based on what you're watching and listening to, is that that person deserves the death penalty.
Correct.
Okay, so it's based on the actual event that you saw. That's where you're focusing on your belief that it deserves a death penalty.
Correct.
So if you were in a situation where there was a similar case like that, and at the end of it you knew you were guilty, would you automatically vote for death?
I would consider everything I've seen before I make that kind of a decision.
Okay,
I find that the death penalty is a very strong penalty, and I would want to make sure that that was warranted after everything.
okay. And being that it's a strong penalty, you still find yourself closer to voting for death than further away. Is that right?
Possibly.
Okay.
That's why I say like a 6, yes.
Okay, 6 or 7. And so I'm trying to understand why that is.
Just what I feel like. I don't know what else to say.
Okay. Now, you said you wouldn't vote automatically for the death penalty. I think
No.
that's what you said. And you said you would have to hear everything.
Right.
But in the circumstances that when you're watching TV, what is the reason why you are comfortable with yourself saying that person deserves the death penalty, but then when you're out of the box of watching the TV show, you are not?
Because my heart is that I want to believe people. I try to trust people. My husband always tells me now that I trust people too much, but I feel like I want to do what's best for that person, and I want to see the best of that person.
Okay.
So
And so that's your natural instinct.
that's my natural instinct.
So when you get away from a TV show, real life's different.
Yes.
Okay. Do you think that that changes the way you feel about the death penalty because of that feeling itself?
It's hard to put somebody to death, I think. I feel like, you know, I'm, again, like a very trusting type of person, and I care about people, so I don't want to do something that's not justified.
Okay.
But when it is justified, that's what I feel like should be done. So I don't know what else to say about that.
Okay. Now, generally, you understand that there's what's called aggravating factors and mitigating factors.
I've heard that, yes.
What kind of things would be important to you to know about the person that would help you decide whether that person deserves a life sentence?
Objection.
Sustained. Rephrase, please.
Okay. What kind of things are important to you as a juror in terms of the mitigation?
Objection.
Sustained.
Yeah,
I don't know what that
saying
means.
Yeah, they're saying they don't want me to answer the
Okay.
question. She's
Objection.
saying
No,
they can't.
sir. No, ma'am. No. Mr. Lunneman, enough. Disregard that last statement. The statement and objection, ma'am, and I sustained it, which means you cannot answer the question. All right?
Okay.
Thank you very much. Go ahead.
Okay, I'm going to talk to you about some mitigating circumstances, and you tell me if you can consider them. Is that fair?
Okay.
Okay. If a person has suffered through racism in their life, is that something you can consider as a mitigating factor?
I don't think so.
Okay. Thank you, ma'am. Judge, can I come sidebar?
You may.
Okay, how are you? I'm back to ask you some more questions.
Hold on one second, Mr. Lemon. Let me see if the mic's working. Is the mic working? Okay, go ahead.
Okay.
Okay.
I asked you a question about racism,
Yes, sir.
and I just want to kind of clarify what your position is, okay? If someone is charged with first-degree murder, they're facing the death penalty, and they put on evidence that in their life that racism adversely affected them, could you consider that as a mitigating circumstance?
That's tough for me. I don't know that racism is an excuse for murder.
Okay,
Maybe it's a factor in the way the personality has developed over time, and I would have to think about that, but I don't think it's an excuse.
okay. Would you give it consideration if it's presented to you as a mitigating factor?
I'll consider it, just like anything else that's presented. I would definitely consider it.
Mr. Lemon, let me intervene here for a moment. Ma'am, I want to clarify something.
Yes, ma'am.
From a legal standpoint. Mitigation is not offered as an excuse for murder. Is that what you think mitigation is for?
I thought it was racism is an excuse.
No, ma'am. Mitigation is reasons why a jury would believe or a juror would believe that a life sentence without possibility of parole is the more appropriate sentence for someone who's been convicted of murder, of first-degree murder.
Okay.
It's not an excuse for murder, okay?
Okay.
I just want to clarify that, so
Okay,
that, because it seemed as if you all are talking past one another. All right, with that explanation, go ahead, Mr. Lenham.
Okay.
So on that note, do you feel that racism, the effect of racism on somebody's life, if that's presented to you in consideration of mitigation, that would be an excuse in your mind?
Objection.
She just,
Hold on.
He's asking for weight now.
No, I'm not.
No. Rephrase the question, Mr. Lenham.
Okay.
I know what you're trying to ask, but rephrase it.
Okay. So what I'm hearing is you saying your initial gut instinct is, someone being black, someone dealing with racism, that's not an excuse for murder. I understand that's the concept that we started off with, okay?
correct.
My question is, do you believe that if you were presented evidence in a penalty phase that dealt with that same issue, racial or race or something with racism having a cause and effect on a person that is offered as a mitigation, do you think that is an excuse?
I thought she said not to talk about it as an excuse.
Oh,
I'm confused now. I'm
yeah,
sorry.
Here's the way it works. You said from the very beginning you believe you're fair and impartial.
Yes,
You said you'd be honest about everything,
yes,
okay? The judge, her responsibility is to tell you what the law is.
yes,
But she's only telling you the law in the hopes that you will follow it.
Yes,
Because
sir.
not everybody is going to follow it, because there are things that happen to them in their life or beliefs they have that kind of step on their responsibility as being a juror.
okay,
You told me outright when I asked you the question about racism that you thought it was an excuse and could not be used for murder as an excuse. Correct? We're on the same page.
right.
Okay. So what that tells me, ma'am, is that you have a feeling, not sure if it's strong or weak, but you have a feeling that people using race as an excuse in some form in life generally is an excuse. It's not something that you agree with.
Objection. There's no question.
Sustained.
You following me?
I follow you. Yes.
Okay,
Sustain the objection.
I understand. So my question is, do you believe that you're going to have difficulty in considering the effect of racism on Mr. Loyd in the penalty phase as mitigation?
No, I don't have a problem with that.
Okay, so tell me how that compares with what you had told me about it being an excuse.
Objection. This is asked and answered.
Yeah, sustained. Move on.
I'm asking for a comparison, Judge.
We have a
Move
sidebar
on.
on.
Move on.
All right. How important is it to you that jurors respect each other and their decisions?
I respect everybody, so I don't see that. I think that's what everybody should do.
Okay, so you believe that at the very least jurors should respect each other?
Yes.
Okay. So the way it works in a death penalty case, for you to get to the point where you are going to have to make a decision on the life and death of Mr. Loyd, is that there will be a conviction that takes place in the first trial, the first part, where he is convicted of first-degree murder. You understand that?
Yes, sir.
And then we go to the second part, which has its own set of rules, which we're going to talk about, which you said you weren't aware of.
Correct. Yes, sir.
Okay. So the first rule is that the state is going to put on evidence of aggravating factors, and there may be stuff that obviously come from the first trial, the trial,
Yes, sir.
and then the defense is going to put on mitigation in the form of experts, witnesses, other things,
Yes.
and then you as a juror have to take that information and use it in some form. Okay, you follow me?
Yes, yes.
So the first way you're going to use it is that the entire jury as a whole has to reach an agreement that there's at least one aggravating circumstance that has been proven beyond a reasonable doubt.
Yes.
Can you do that?
Yes.
Okay. From that point on, it's all about you and your decision-making process. Because from that point on, all the way up to the time where you make a decision whether life and death is appropriate, it's all you making the decision.
Yes.
First thing you're going to do is you're going to look at the aggravating factors that the state has presented to you. And you have to determine whether those aggravating factors, some, all, or otherwise, have been proven beyond a reasonable doubt.
Yes.
Can you do that?
Yes, sir.
The next thing you're going to do is you're going to have to look at the mitigating factors, mitigation, which could be anything.
Yes.
Could be things about, like I told you, racism, mental health, other things. And you're going to have to look at those and see if they were proven to a lower standard than what reasonable doubt is. All right?
Yes, sir.
And once you decide that they've been proven, then you're going to look at those and you're going to give them weight, individually and collectively.
Yes.
You're going to give the aggravators weight, individually or collectively.
Yes.
And then you're going to weigh the aggravators versus the mitigators.
Yes.
Now, if the mitigators outweigh the aggravators, you have to vote for life, period.
Yes.
So if there's one thing that stands out to you that outweighs all the aggravation or a group of things, you have to vote for life.
Yes, sir.
Can you do that?
Yes, sir.
Okay. If the aggravators outweigh the mitigators, you may vote for death. You are never required in Florida to vote for the death penalty. You make the ultimate decision.
Yes.
Okay, you understand that?
Yes, sir.
Okay. So let's say you believe that the aggravators outweigh the mitigators, but you have some personal reason, whether it's mercy or something you heard or something you saw in the courtroom that was part of the case, or something internally that is driving you, you never have to vote for death. You understand that?
Yes, sir.
Then ultimately, each of those verdicts are placed in a basket. Individual 12 verdicts are placed in a basket, and there's a determination made whether there's a unanimous vote for the death penalty, meaning everyone has to vote for the death penalty for it to be a death penalty case, or if one or more jurors vote for life, then it's a life case. You understand that?
Yes, sir.
So it only takes one vote to have a life sentence.
Yes, sir.
Okay. So you're with me on that?
Yes, absolutely.
Okay. Now, there is something else that's called victim impact. There's an instruction that says that the jurors can listen to and be presented with victim impact, which is evidence of the uniqueness of the person who was killed.
Yes.
So there may be family and friends that come in and talk in some way, or present a written statement and read it, present photographs. It's focused on uniqueness, not how it affected them, because the legislator doesn't think that's important to Mr. Loyd's situation, only the uniqueness of the person. Now, the law says you cannot consider that as an aggravating factor.
Okay.
So you get to hear it, but you cannot consider it.
Okay.
Can you follow that law?
Sure.
Okay. Now, I know the judge talked to you about insanity a little bit.
Yes.
Have you ever had an experience that while you're watching Law and Order, there's someone who commits a heinous crime in your mind and then tries to get off in insanity?
I'm sure I have.
Do you remember what you felt?
No, I don't remember.
Okay. So you can't think of anything that you've watched over the years where insanity came into issue that you would have felt one way or the other?
No, I haven't felt one way or the other.
Why don't you feel it's an excuse?
Insanity as an excuse?
No, why don't you feel that insanity is an excuse?
Well, insanity can be an excuse, I believe.
No, an
There are
excuse for
occasions when
committing-
that would be.
I misspoke. Let me rephrase it so we're on the same page. When I'm saying excuse, that a criminal is using that to try to get off. Okay?
Yes.
So why don't you think that a criminal who committed a murder is trying to get off of that murder by using something that's not true, which is insanity?
I would think it has to be proven to be true.
Okay? Which
That-
you're right.
That's what I believe.
Okay, so you don't have any other feelings about that
No,
in relation?
no,
Okay.
no, sir.
Thank you. I have nothing further, Judge.
All right. Anyone need to approach?
No, Your Honor.
All right, ma'am, we're going to send you through for a third round of questioning, and it's the final round. I know, it doesn't feel as if you've won anything. However, you've now got a coveted purple dot coming your way. I'm changing your color. And all that means is that when you're phoning into the jury room, let me take this off, make sure you hear me. When you're phoning into the jury room, you're listening for the date and time the purple group is to return. I don't know when that is because it is the final day of jury selection, and we will be picking the jury from that group. So we're going to give you a packet, and it's a sequestration packet. It has in there all the explanations of what to expect if you are sequestered, if you're picked for the jury and sequestered. You're going to have to pack your suitcase and come to the courthouse the next time with your suitcase packed and ready to go. Leave it in the trunk of your car. If you're selected for the jury, we'll make arrangements with the deputies for you to get it. If not, you just go home and unpack. But we sequester the jury immediately upon selection, so you'll need to be ready for that, all right? Don't start calling that number before Friday after 5. There's a slip in there with a phone number to call. We won't need you at the earliest next week, so don't bother calling before 5. But once you start, just start calling every night, and you'll eventually hear a message for the purple group to come back. Any questions?
No.
All right, thank you, ma'am. We appreciate your time this afternoon. You have a good afternoon. You're free to go. All right, give me 1 second. Let me get this straightened out. All right, the juror in seat number 4, please. And again, we are on panel 3. All right. Good afternoon, sir. How are you?
Okay,
Sir, you're juror number 578, is that correct?
578.
Okay, I'm going to need you to use that microphone so we can hear you. All right, we have,
Yes, 578.
all right, thank you. Did you tell me that you'd heard something about this case?
I heard on the news when that happened
Okay. How much did you hear?
a lot.
A lot? Did you follow it pretty closely?
I'm a truck driver at the radio, all the people talking about
Oh, okay. So do you listen to talk radio?
music. My English is not good.
Your English is not good?
No.
Okay. Are you having trouble understanding everything that's going on in the courtrooms?
I understand I said 60 or 50%.
Okay.
Not everything.
Do you believe your English is good enough to sit through a trial, or do you think you would have a problem?
I will have problem.
All right. State? Any
No
objection?
objection.
All right. Thank you, sir. We appreciate your willingness to serve, but if you can't follow the trial, you can't be a juror. But thank you very much for coming in. You have a good afternoon. You're excused. Juror in seat number 6.
Yeah, mostly.
Good afternoon. How are you?
I'm good. How are you?
I'm well, thank you. You're juror 847, correct?
Yes.
All right. We're going to be asking you a few questions. I need to ask you preliminary questions. Last time you were here, you told me you were a full-time student. Is that correct?
That is correct.
But you felt that on Friday, you felt like you could keep up with your coursework if you were on the jury. Do you still feel that way?
Yes.
Okay. So you don't have any issues with your schoolwork?
No issues.
All right. You said you'd heard something about this case. Can you tell me what it is you've heard?
Yes. So, I have heard and know some of this case from the Orlando Sentinel and the local news, and that is that the defendant allegedly shot and killed Officer Debra Clayton at the Walmart parking lot
Okay.
over in Pine Hills.
How much news coverage did you follow?
I mean, if it was just like on the TV, I don't really watch the local news that often. So I would just say sparingly, if that makes sense.
Right. Did you watch it? Have you watched it since it happened, straight through to now, or is it just been sporadic, or what?
It's been sporadically. I did read Friday morning in the paper the story that they put out on this case, saying that they were going to begin jury selection, and
Okay.
that is as seen.
Can you hear me when I have this mask on? Okay,
Yes.
great. Have you talked to anybody? I mean, prior to coming here, have you talked to friends or family or anybody about the case when you saw a story, or has anybody talked to you about it?
Just my parents, who I live with.
Okay. Is there anything about the news coverage that you watched, the conversations with your parents, anything like that, that led you to form an opinion about Mr. Loyd's guilt? You didn't form any opinion?
No.
Right, so jurors are required to presume that Mr. Loyd is innocent until and if the state can prove that he's guilty beyond a reasonable doubt. Do you believe that despite everything you've read or heard or talked about, that you can do that?
Yes.
Have you ever thought about the death penalty before coming into this courtroom?
I guess so.
Okay. Do you have any religious or moral objections to the death penalty?
No.
Are you someone who believes that in some case, are you someone who believes that in any case where someone's convicted of first-degree murder, they should be sentenced to death?
I think that the death penalty should be imposed in every case of capital murder.
All right. So you heard me describe what the process is for determining whether your vote's going to be life or death. And it is that you listen to the aggravators presented by the state, the mitigators presented by the defense. You go back into the jury room. You can discuss it with your fellow jurors as much or as little as you want. You've got to weigh those aggravators and those mitigators. You've got to listen, think about all the facts and the evidence. And in the end, you need to come to a decision as to whether or not life or death is the appropriate sentence. So if after you did all of that, you believed that the appropriate sentence was life without parole, would you be able to vote for that?
Yes.
And same thing, if you believed that the death sentence was an appropriate sentence, would you be able to vote for that?
Yes.
Do you have any hesitation or concerns about that?
I do not.
You heard me tell you that Mr. Loyd has raised the defense of not guilty by reason of insanity. Right? That would be in the guilt phase when you're trying to decide whether he's guilty or not. If the burden's on the defense, it's by clear and convincing evidence. If at the end of the guilt phase, you believe that they had proven that, would you be able to return a verdict of not guilty?
I don't know.
Okay, tell me why you're hesitating.
Just because of what I have seen.
What you have
through
seen?
the Orlando newspaper and the local news.
So what you've seen about the case
Correct.
would stop you from being able to, would it stop you, or you're not sure whether it would stop you from accepting evidence about insanity?
I'm not sure, to be quite honest.
Okay. Then here's my last question for you, and then I'm going to let the attorneys ask you some more detailed questions.
Right.
You remember I told you about Mr. Loyd was convicted of murdering Miss Dixon and the unborn child, and he's been sentenced to life without parole on that. You can't use that as evidence that he's guilty in this case. You understand that?
Yes, I understand that.
Can you follow that instruction?
Yes.
Can you put that out of your mind when you're trying to decide whether he's guilty or not?
Yes.
All right, so your only hesitation in this case is on the insanity defense. Is that correct?
That is correct.
All right. Thank you, ma'am. State, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
What is it specifically that you saw or read that is giving you some pause on issue of insanity?
I have to think.
It's okay, take your time,
Yeah.
no rush.
Is I don't know, like a good enough answer? 'Cause
Okay,
I
so
don't-
nothing like specific is popping out?
I can't, yeah, I
Okay.
can't remember.
You're a student, what are you studying?
I'm studying secondary education.
So, like, would that mean like high school or college education?
High school, like middle school, high school education.
Are you contemplating being a high school teacher?
Perhaps. I'm kind of going back and forth between maybe 8th grade or like early high school English.
Okay, so the teacher part is set. It's the age that you're not sure about.
Yes.
All right. Well, I asked that because you used some pretty specific terms when you were describing things like defendant, allegedly, capital. These are not terms that we hear all that often. Do you know where you got those terms? Is it just
Well,
reading?
I took some criminology and law studies classes before I came to the conclusion that I wanted to become a secondary teacher.
Okay. So my recollection of the Orlando Sentinel article that you are referring to is that it contained a pretty detailed paragraph about the defense that the defense attorneys and Mr. Loyd were going to put on. Do you remember that?
A little bit. I didn't read like the entire article,
Okay.
but
My recollection is that it also included the state of Florida, our view, and how we have been attacking that in other hearings. Do you remember reading that?
a little bit.
A little bit, okay. Given the knowledge that you have from that article, and I'm glad that you're reading, because People 21 don't all that often anymore, but do you think that you could set aside all that information and really be fair and impartial to Mr. Loyd and to the state with that information that you have?
I believe so, yes.
Okay, okay. So talking about school, going back to your school, how many years of college do you have now?
I just finished my associate's degree
All right.
back in August. So
Congratulations.
Yeah.
So let's say that you went to class next week and you were not here and you were asked to write a paper and you had to take a pro or con position on the death penalty. All right, this is not one of those where you can turn in, I'm arguing both sides. You have to pick one side and then lay out your argument. Which side would you pick and why, please?
Well, I think it's dependent on the case. So I'm not necessarily against the death penalty. I think it just depends on the nature of the murder, the victims who are involved. If the murder was conducted in a way that was depraved, there was torture involved,
Okay,
things like that.
okay. So you would be looking for maybe the way the murder was carried out?
Right.
That would be an important aspect of it for you? Okay. But I take your response to mean that if you're willing to look at the circumstances, that you do not believe that the circumstances of every first-degree murder would warrant a sentence of death.
That is correct.
In other words, if I'm right, if I'm wrong, tell me, but there are circumstances where you believe someone could commit a first-degree murder, even a premeditated first-degree murder, and life would be an appropriate sentence.
Yes, I do feel that way.
Okay. Given your knowledge of the case, and in fact, I heard you say the officer's name, Debra Clayton, so you know her name.
Yes.
Did you know anything else, or have you learned anything else about her other than she worked for the Orlando Police Department?
Nothing.
Okay. Anything about the fact that a law enforcement officer is the alleged victim in the case that you think would prevent you from being fair?
No.
Would you be more likely to vote for a sentence of death solely because the allegation is that a police officer was murdered?
No.
I'm going rapid fire here. I apologize.
It's okay.
If one is, you can't wait to get back to class and get away from this situation, and 10 is, you really hope you get to pick out which seat you get to sit in the jury, as to how much you want to be a part of this process, where are you on a scale of 1 to 10?
I would say I am at maybe a 7.
A 7. Okay. And briefly, why is it that would mean to me that you're more interested in being a part of it than not? Is that right?
Correct.
And so why would you be a 7? Why are you more interested than not? Because as you can imagine, we get some people that are 2 or 1. So.
Right. I think this is an important trial.
What about it? I mean, I think I know. To you, what makes it important?
I feel it is important. I mean, I feel it holds great significance in the community.
Okay. And you're willing to take that responsibility on?
Correct.
I want to ask you now about, specifically about insanity, because the judge was talking to you about it earlier, and you seem to struggle with that a little bit. But now we've been talking, I'm hoping you've been thinking about it more. We don't need definitive answers on everything, but Mr. Loyd has a right for you to be able to be fair to any defense that he raises and consider it.
Right.
And I heard you say you had some hesitation on that.
Right.
Do you still have that hesitation?
No, to be honest with you, I'm just very nervous.
Okay, that's fair. Any doubt in your mind about your ability to come back with a verdict of not guilty by reason of insanity if that defense is proven to you?
If the defense is proven to me, then yes.
Right, because you understand it, normally it's our burden, but as to that defense, it's the defense burden.
Correct.
Okay. That's the only questions I have, Judge. Thank you, ma'am.
Thank you, Mr. Williams. Mr. Lenneman, you may inquire.
Thank you, Judge. Good afternoon. How are you?
Good afternoon. I'm good. How are you?
Great. Thank you. Okay, I'm really interested in talking about this statement. And to be honest with you, it concerns me greatly. You said that this is an important trial
Right.
and has significance in the community.
That is correct.
Okay. Why?
Well, I think it's important because an officer was killed in the line of duty.
Okay.
And I think as well, I mean, it was just all over the news as well.
Okay. So besides being all over the news, why else is it significant?
I think this is also perhaps despite Officer Debra Clayton's murder, something of police brutality as well, because I know
And what do you mean police brutality?
I mean, in the fact that when, as I know, the defendant was apprehended by police, he was. What do you know about that? He was brutalized. I mean, he lost his eye.
Did you see the video footage?
I have seen the video footage.
Okay. More than once?
On the news.
Okay. And what did you think of that?
I thought it was wrong. I thought it was unprofessional, despite the fact of what happened to Officer Debra Clayton.
Okay. Now you said, going back to one of your statements, you said this was important or significant because of the murder of Debra Clayton.
Correct.
Why do you believe that in the context of your involvement is that important?
Because, I mean, I believe she deserves justice.
Okay. So you believe that she deserves justice,
Yes,
and you want to be part of that justice.
correct.
And you read the newspaper articles that account for what happened.
Yes, I have in the past.
And part of your original response about not being able to find insanity was based on things that you had read.
Read and seen in the news, yes.
Okay. Now, do you think it's fair for someone to be seated on a jury that has already a built-in belief of conviction?
I don't think it's necessarily fair, but I mean, everything that I know of this case is just from what I have seen in the media. If I were presented evidence on the contrary, then I believe I could change my opinion.
Okay. So you would need to hear evidence from the defense in order to change your opinion about what you've already read and heard.
Correct.
All right, thank you.
All right. Let me see the attorneys at the bench, please. All right, ma'am. I can't tell you how refreshing it is to have people in here who actually want to serve on a jury and are interested. We appreciate all the time and attention you've given for this case. I think you probably know a little too much about the case to be able to sit as a juror on this one, but I hope you get onto a jury soon. All right, thank you very much. You're discharged as a juror. You're free to go. All right, that's it for the morning sessions. How are we doing on, you only have 3 of them? All right, here's what I want to do. It's a little after 2:45. The 1:30 group is here. I think I want to take a break. We've got 3 of the 3 o'clocks here already. I want to see if we can get the 3 o'clock group here and do what we did yesterday, which is bring both groups in, charge both groups at the same time, go through cause challenge, the publicity issue, and then finish up questioning both groups. All right?
Your Honor, at this time, the state would move the court again to question the jurors in groups of 5. The rationale for that is given the repetitive nature, and I don't use that in a pejorative sense. I understand why it's being done. But if we're going to explain the process where counsel is for either side, then I think it is just so much more efficient with no prejudice that I've seen to do it 5 jurors at a time. I understand why the court is permitting it. I understand the rules and why it's happening. But I do think that I have yet to see any indication that it would be a problem to do 5 jurors at a time. I understand it's court's discretion. We're just moving it this time.
All right, defense, do you want to weigh in on this?
Yeah, Judge. I think the reason this court
need to turn your mic on, please.
I think the reason this court decided from go on this situation was, number one, this court experienced, I know Mr. Williams wasn't present, but this court experienced prior jurisdiction with Mr. Loyd on the Dixon case and the process and how it worked, and I was pretty successful at doing that. Obviously, the court was aware that this was even more complicated because of the issue of insanity and the issue of a law enforcement officer. So I would object to that. And I would just note for Mr. Williams' situation that had we had 5 jurors on that, 4 of them would have heard about the beating Mr. Loyd took. And I know that's unfavorable to the state, favorable to us, but it could be the opposite at any given time.
Yeah, I'm not looking for speed here. I'm looking for this to be a fair process where we don't lose a bunch of jurors to a statement that was made. Mr. Lemon is right. She is not the first juror to talk about Mr. Loyd being beaten by the police and losing his eye. And if I have 5 people sitting there, 4 of them don't know about it, and now I've got cause challenges on the other 4. So we're not doing badly. We have 12 going through so far to general voir dire. We're ahead of where I thought we would be, actually. So we're going to keep going with this, and I'll keep an open mind about it. If at some point I think we change the method, we will. I'm going to change slightly next week how I'm going to bring these groups in. But for now, we're going to stick with what we've got. We're going to join the 2 o'clock, or the 1:30 and the 3 o'clock, and hopefully everyone will ask the questions they need to ask in an efficient manner, and we will move along. So take your recess, folks.
Yes, Your Honor.
Is there one other thing you wanted to say? No, okay.
I said yes, Your Honor. That's
All right, recess.